More than a decade ago, after a drawn-out will they or won't they, Governor Andrew Cuomo closed the door on the possibility of using hydraulic fracturing to extract oil and natural gas from upstate New York with an executive order following the 2014 elections restricting fracking in the state. Then, when Democrats took control of both houses of the state legislature, they codified these restrictions and imposed additional restraints at the end of 2024. But not everyone has given up on the economic dream of fracking in New York, primarily in the southern tier, and there is a federal lawsuit challenging the constitutionality of New York's broad restrictions. For more on the legal maneuvering and what it could mean for the Empire State, we're joined on the Capitol Press Room by Yvonne Hennessey, a partner with the law firm of Barclay Damon. Well, before we get into the federal challenge to the status quo, I'm interested in what the current landscape means for the extraction of natural gas or oil in New York, because I know we have an executive order and laws on the book restricting fracking, which is basically a process of injecting water, sand, and chemicals, and maybe carbon dioxide into the ground to get at oil and natural gas from rock formations. But does that mean there's no other way to get at New York's fossil fuels, or is it just that the other ways are maybe cost prohibitive, or something else might deter people from going after them?
So we've historically drilled in the state of New York different types of natural gas for decades and decades, probably going back centuries. So there was traditional methods, including some hydraulic fracturing that had occurred, getting at different formations. But most of those formations have been tapped, et cetera. So what's really left to be explored in the state of New York is the Marcellus and Utica shale. And back more than a decade ago, everybody in the southern tier in the state was very anxious to see, because there is a wealth of shale to be developed in the state of New York. But at this point, the companies have lost interest in New York. Nobody's really drilling actively for these shale formations in the state of New York. There just really isn't the technology to do so.
Well, property owners who could benefit financially from fracking in the southern tier are now challenging the constitutionality of the state's restrictions. What rights are they claiming have been violated?
So their primary argument is under the Fifth Amendment of the United States Constitution, effectively a regulatory takings, that the value of their property has been diminished to effectively zero because they can no longer lease it for shale extraction. And what's really interesting here is the landowners who have brought the lawsuit have sold the surface rights to their property. So all they own are the mineral rights. And so that will make it a really interesting regulatory takings case for the court to decide here, because effectively their mineral rights have zero value at this point, given New York's ban.
Do you have a sense of why this case is being brought right now? I mean, does the Fifth Amendment claim represent some sort of new and novel legal claim, or is the judiciary different right now, which might invite this type of claim, or is there something about attitudes toward fossil fuels right now that might make this particularly a ripe time for filing this type of lawsuit?
I think there's a couple of reasons. I think one, there's very much a strong focus, and you see it in the complaint about affordability and availability of energy supply, right? Obviously, we've got stuff going on internationally, but also here within the state in terms of rising costs for energy. I also think the southern tier, particularly landowners there, have seen the wealth that has come to the northern part of Pennsylvania without all of these environmental concerns, et cetera. So I think that's part of it as well. But I also think you're seeing a lot of change going on at the federal administration about focusing on fossil fuels. You're seeing a little bit here in New York about recognizing an all of the above strategy that, reliance solely on renewables may not be foreseeable, at least in the next decade or so. And so we need to start looking at other ways to secure energy, or else we're going to have a major, major reliability and affordability crisis in New York.
Well, is there a clear line in the sand historically when it comes to what people can do on their property to make money? Because I live in Saratoga Springs, for example, and I have maybe local zoning rules or even state laws that would prevent me from, say, opening up a bar at my house during track season, or I couldn't run a brothel on my property. So clearly the state has some rights in telling people what they can and can't do. But is there a clear distinction, or is there a reason why this might be different from those outlandish scenarios that my wife will never, ever allow me to do?
I was going to say, definitely wouldn't allow you to do that. So I mentioned earlier, what's really unique about this and distinguishing from your situation is the only property rights these landowners have is the mineral rights, because typically when you look at regulatory takings cases, the cases rise and fall about whether or not it removes all economic viability of your house, right? So for example, you may not be able to have a bar or a brothel on your property, but that doesn't remove all economic viability of your property. There are other things you could do there. Here, the landowners have sold the surface estate. So all they have are the mineral rights, and what value remains of those mineral rights if they can no longer lease them for the extraction of gas.
So sometimes we will see people might have an interesting legal argument and maybe it generates some buzz, but there's always questions about standing, and that can sometimes cut a case off at its knees. Is there a reason to think that the plaintiffs here are going to be able to have their day in court, so to speak?
So standing is one of my favorite arguments as a energy litigator. I argue that all the time. I don't see standing being a problem here. And I would say typically we don't see the state arguing standing. I think it would be very hard here for the mineral rights owners. I think some of the defenses we will see are perhaps statute of limitations. And that's going to be a complicated case here since I think we started this conversation. The ban was initially acted in 2015 when the seeker finding statements were issued by the state, although there's been some more recent developments that have cut off other ways of extracting gas. So I think statute of limitations will be interesting. I think it will also come down to your typical regulatory takings case is usually for compensation. What is the lost value of your property? That's not what they're seeking here. They're basically seeking a declaratory judgment and an injunction prohibiting the state from enforcing the ban so that fracking could occur. So I think that's going to be an interesting issue that will have a lot of debate in front of the court.
Well, is there anything about the way the executive order or the subsequent laws were written that opens them up for a legal challenge in a way that maybe if state lawmakers choose to revisit this in a more nuanced way, they can still try to achieve their environmental goals while still withstanding a potential constitutional challenge?
Well, again, that goes down to whether or not they have to pay the compensation or whether or not the ban itself is going to be valid going forward. So I think that's what's going to be the crux here. Now, in federal court, you can't sue the state for damages. We have this doctrine called Ex parte Young that you can't sue the state and federal court for damages. But interestingly, the judge who's assigned to this case is a former New York State judge, so he'll have a lot of experience in those type of issues, and it'll be interesting to see how he rules on it.
Well, taking out your crystal ball then for a second, what are some of the pathways in which this case could proceed from, I guess, maybe the most expansive type of ruling to some of the more narrower types of interpretations of this case?
So, the narrow interpretation could very much be focused on just these individual landowners, because most of the people in the southern tier, I suspect, and I certainly haven't gone back to look, have not sold their surface rights. So these are landowners who live in a location, have farmland, et cetera, and still own their mineral rights. Those cases are going to be much harder for those folks. So there could very well be a narrow ruling focused just on people who only own the mineral rights. And again, we'll see what Judge Brindisi does. The broadest expansion could be, and this would be interesting to see if a court would go this far, which would be prohibiting enforcement of the law. It's interesting who's been sued in this case. They've sued the Department of Environmental Conservation and the Attorney General's office. They're not against the legislature, right? So it's really interesting to see how this is going to play out. I also think, regardless of what happens in court, it brings to mind the political importance of this case and raising hydraulic fracturing awareness again in this environment in terms of whether or not it would be approached from an all of the above strategy. And maybe you'll see some political movement either at the federal level or the state level to look at this as another option. I think there will be significant opposition to that, as there was leading up to 2014. But from experience, there has not been the major environmental catastrophes in Pennsylvania that people envisioned 15 years ago. So perhaps this is another way for New York to become a little bit more energy independent.
Well, a lot more to follow moving forward, but for now we got to leave things there. We've been speaking with Yvonne Hennessey. They're a partner with the law firm of Barclay Damon. Yvonne, thank you so much for making the time. I really appreciate it.
Absolutely. Thank you so much for having me.
Fraud and lawsuit abuse raise car insurance costs for New Yorkers. Reforms are being proposed to mitigate their impact, but some Albany leaders want to keep the status quo. Information on these reforms is available at keepnewyorkaffordable.org.
Support for the Capitol Press Room is provided by New York State United Teachers, a statewide union of nearly 700,000 professionals in education and healthcare.